Okay, so we're live now. And lots of people are joining us. That's wonderful. Thank you all for joining us today. I'm just going to wait for a few more to join because we've got a lovely big audience today.
Good to know the link's working.
Yeah. So I'm just going to, I can see the numbers flying up here. Lots of you joining us. So just give us a moment and I'll do some introductions for you all. Oh, we've got a lovely attendance today. That's fantastic. Thanks everyone, by the way, who's joining us, because we've had just about 1,000 people registered for this webinar, which is terrific. It's wonderful to have so many of you kind of joining us. So I'll just wait a few more moments because I see quite a few are still joining us. Won't be too long though. Okay, right. To save any further delays, I'm going to kick off. So my name's Simon Blanchard. I'm co-owner and partner at Data Protection Network Associates, and I've been with the business for just over 10 years now, in fact, in total. So I'm your host for today's webinar. I've done a switch actually with Robert today. Robert often hosts, and Robert's joining us on the panel today, which is wonderful. So many of you who've joined us before on these events will be aware that we have two arms to Data Protection Network. First of all, it's the resources, as I call it, which is that we produce lots of kind of practical industry guidance, topical articles, news stories, all of those kind of things that are all published on our website, which is dpnetwork.org.uk. And obviously, we run quite a few events as well through that. Many of you, I say, may have come to these webinars before where we cover various data protection and privacy related topics. In addition, we're a specialist consultancy in the world of data protection. So we're a consultancy, but also a training provider. And we work with all sorts of organisations, both large and small, and also a number of charities as well, including kind of, some multinationals, things like that. So arrange to help them to manage their data protection governance programs and all other aspects really relating to data protection. So enough about us. I'm going to start to do some introductions. I'm just going to pop our slides up for you. There's not going to be many. Don't worry, it's not death by PowerPoint today. There's only 4 slides. It's nice and short. So obviously our topic for the day is Unwrapping UK Data Reform, which is obviously, as I said, a popular topic. We've had almost a record number of you join us for this, which is fantastic. So thank you very much. And I'd just like to introduce you to the panel that we have today. So some familiar faces here for those that joined us before. So first of all, we have Robert Bond, who's Senior Counsel at Privacy Partnership Law. Robert, would you like to say a few words to introduce?
That's very kind of you. Thank you, Simon. It's nice to be a panelist, not a moderator today. So I'm with Privacy Partnership Law. I'm also an industry commissioner with the Data Marketing Commission, and I'm focusing a lot on the DUA bill. Thank you.
Wonderful. Thank you. And Camilla, we have Camilla Winlow, who is Head of Data Privacy at GemServe.
Hello, everybody, and it's really nice to be part of this panel as well. Quite some esteemed experts I'm up against here, so I'll try and be as interesting as they are. I am not just the Head of Data Privacy for GemServe, which is part of Talon Group, which is a big sort of data and technology consultancy, but I also chair the Privacy Subcommittee for the Smart Energy Code, which handles the sharing of smart metering data. And I'm part of the governance committee and the AI task force for the Data and Marketing Association. So got some associations with Robert there. And I'm also one of the publications advisory board members for the International Association of Privacy Professionals. So yeah, looking forward to the discussion.
Fantastic. We're delighted to have you with us, Camilla. That's wonderful. And I'm sure we'll be talking about a few of the topics that you've mentioned there through the course of the day. And Steve. So we have Steve Wood with us, who's founder and director of Privacy X Consulting. Hi, Steve.
Hi, Simon, and thanks very much for the invitation to join the discussion today. So really looking forward to it as well. Yeah, I'm founder and director of Privacy X Consulting. So this is my own consulting company that I set up about 3 years ago when I left the ICO. So I worked for the ICO for about 15 years, 6 of those as the deputy commissioner responsible for policy. When I led the development of the ICO's guidance, I represented the ICO on the European Data Protection Board. I was the chair of the OECD Working Party on Data Governance and Privacy. And I also led the ICO's work on the age-appropriate design code and children's privacy, which children's privacy is still an area I specialise in. I'm also undertaking research in that area at the moment, as well as part of my portfolio, working with the London School of Economics and Five Rights as well.
Fantastic. So I hope you'll agree we have a wonderful panel today to tackle this topic. So what we're going to be covering today is the Data Use and Access Bill in particular here. So I'm not going to talk hugely about this. Obviously, I'm here to chair the event really, but I'm just going to give you just a few kind of headlines really about what the bill's about. Many of you may well be aware, but for those who've not seen so much about it, so it's estimated by the government to bring to £10 billion boost to the UK economy over the next 10 years. So big numbers in there. To also set baseline standards for digital verification solutions. So it can make sure that our digital ID services are secure and also reliable. So they're talking about bringing in a certified trust framework for that, which we'll cover in a few moments. There's plans for smart data schemes that will enable the secure sharing of customer data between service providers, and also to unlock the power of data to drive efficiency in our public services, a range of public services, but in particular, I think there's been a lot of focus on the area of health and social care, being able to share data between the various different providers. So we'll go into those in a few moments. But if we look specifically at data protection, it's just to be clear that this really affects all of the three kind of main laws that we have relative to the UK. It's going to involve some amendments to the UK GDPR, also changes to the Data Protection Act that we've had around since 2018 and in its current flavour, and also our electronic communications, so the privacy and electronic communications regulations that we have that regulate the electronic marketing as well. So, and the use of cookies, in fact. So I'm going to make that just a whistle-stop tour on the slides. I'm going to stop there. Let's bring back to the panel. And I think the first thing that we're going to do, just before we kind of launch into the questions, and there's been some fantastic questions that you've all given us in advance, which has been really useful. I'm just going to pop a quick poll on here for us. So we'd like to know your thoughts initially. That's obviously before we've got talking on this. So the question is, do you think that the Dewar Bill should have gone further to ease the burden of compliance on organisations? So I've just published that poll. We're really interested to know what your thoughts are. So the options are yes or no, or just not sure at this time. And hopefully those that are not sure will have gained a view by the end of this hour. We're fairly evenly split, actually. Okay, it's settling down now, so I'm just going to stop there. Okay, so as we stopped, we've got 25% saying yes, you do think it should have gone further to ease the burden of compliance, 36% no, and 37% not sure. So yeah, we have got a fairly even split, maybe with a slight bias towards the no. So that's been really interesting. Thank you. Okay, so I'm going to come back to the panel now in that case and start asking you guys a few questions about the bill. So first of all, I'd like to know kind of from each of you really your reaction to whether you think that the government struck the right balance here with the Data Use and Access Bill, the right balance between encouraging UK economic growth on one side, which is obviously a major thing that they're trying to achieve, but also protecting the rights and the data privacy of individuals as well. So balancing those two things out. And I think if we can ask Steve first of all for your thoughts.
Yeah, thanks so much, Simon. I think it's a really interesting question, obviously, to consider. And obviously, as you outlined in your opening PowerPoint as well, obviously, the bill is quite wide-ranging in the number of different data-related topics that it covers. Obviously, a number of us here as well are particularly interested in the data protection provisions, but obviously it is worth noting sort of the broad scope it covers in terms of digital innovation, really. And I think sort of focusing on the growth and digital business benefits and public sector benefits part first, as you highlighted, you've got that 10 billion boost figure, over 10 years, etc., highlighted. And I think a lot of that is particularly driven, by the hopes and expectations relating to smart data, which I think hopefully will I think, open up new sort of data-driven services and innovation, and particularly around sort of personalized market comparisons, personalized financial advice, helping small businesses sort of understand how they can sort of choose different products and services as well. So the smart data provisions obviously sort of come with that hope and expectation that by opening up more data in a similar way actually that the EU is doing under the Data Act as well. So this is a sort of an overall international trend, but we can actually sort of unlock, sort of new sectors of innovation. Obviously to date, most of the focus on sort of data portability has really been in financial services and open banking, and the idea of the government is to expand that, and clearly that obviously has great potential. I think the one caveat around that is having been around the track a few times on some of these issues, some of you may remember a scheme called My Data, which came with the coalition government from 2010, and it struggled to take off, I think, around sort of data portability in terms of sort of public trust and confidence, people seeing the use case. So I think, it's really important that the sectors that are brought into this, that people and businesses, because businesses will be able to access data about themselves as well, but people and businesses will understand the ways that the smart data opportunities really will actually sort of add practical value to their sort of digital lives and their digital operations as well, and it may take time to implement, etc. as well. And I think that's the same goes for digital identity as well. It may obviously offer significant opportunities to have a sort of a trusted framework for digital identity and accreditation on that to really drive the market in third parties offering sort of federated identity management solutions, which minimize the amount of personal data that people need to provide to verify their identity, and obviously reduces paperwork and the other costs that we know already are attracted to different forms of identity verification, which already take place in the economy in perhaps quite a manual way. So again, the opportunities across a range of business and services are probably there, but again, that's going to take time, I think, to build up and be delivered. I think the data protection parts of the bill obviously is slimmed down considerably compared to what we had previously in the bill that was introduced under the Conservative government. And the data protection elements are relatively modest as well, because the government obviously has had an eye on retaining its EU adequacy decision as well. So you've got some quite sort of targeted measures, which I think can help certain types of sectors and businesses innovate more with data. You think about the research provisions in the bill, that may give more confidence to research, etc. So, there are some, I think, helpful sort of enablers and opportunities, but I would say the key areas for businesses in terms of digital innovation are probably about smart data and digital identity in the main. And then I think, thinking about the flip side of the coin and the sort of the balance with people's data protection rights and what may come from the bill there, I think is obviously worth noting, and probably most people who've studied the bill to some extent know that, the core data protection rights and principles are essentially still all there. They know it's not a radical sweeping away or changing of the core components of data protection that we know. Probably the most notable change is probably the removal of the prohibition, essentially the right not to be subject to automated decision making, and that the switch to that provision having safeguards, that's probably the most significant area. The other areas relating to rights, I would say really clarifications, like the change in terms of DSARs, in terms of the clarification we now have on the face of the law about reasonable and proportionate searches. So I don't think we could say there are major sort of deviations from people's rights and how the core principles apply. But I think particularly in the area of automated decision making, there will need to be monitoring and sort of assessment as to how businesses may sort of exploit what they see as an opportunity there to do more automation and to use people's personal data in that fully automated sense about what the risks and impacts are of that. So that's clearly, I think, a key area to monitor and to see whether it overall requires more intervention from the ICO. We may touch on that a little bit more later. I think the last point to note as well is obviously for multinational businesses as well, they may not want to make so many changes to their data protection governance as a result of this, for example, on areas related to cookies, etc., because they've got global governance, which are rolled out for many jurisdictions. Therefore, it doesn't make sense to change for a sort of a UK-specific piece of legislation offering opportunity when you've got global governance. So that's the other sort of tempering point as well.
Great. Thanks for such a comprehensive answer there, Steve. That's great. And actually, just kind of building on that, just going to the next part I was going to ask is just really how it's likely that the UK would then, with the framework that we'll have in the UK, would sit alongside our counterparts in the EU from that point of view, and what that would look like for organisations that are handling data. You know, some organisations are handling purely UK data, but many that obviously are handling data across Europe or the rest of the world. So might be a good one. If I can start with you, Robert, for that one.
Yeah, yes, thank you for that. I think for multinationals, my experience so far is that they are unlikely to make significant changes from what they're already doing, because what they're already doing works. And to be honest, so many other countries around the world are very GDPR influenced. So I think where they can make changes for the UK only, they may well do so. But overall, I have to say one of the good things about the DUA bill is that it hasn't got rid of the ROPA, and it hasn't got rid of the DPO, and it hasn't got rid of the DPIAs, because those are good data governance risk management procedures. If I might, just to follow on from Steve's excellent comment on the first question, my only concern about the effect of the bill on individuals' rights is so much is now not about consent and everything about some other lawful ground, subject to, as Steve said, appropriate safeguards. My worry is, what are those appropriate safeguards going to be? And will we actually have a regulator who will step up when things go wrong with our personal data? Because it seems like we don't have as much control as we currently have under the existing law. And I think all the hard work that everybody did to comply with GDPR, the return on investment is that it is a good risk management process.
Mm-hmm.
Yeah. No, absolutely. That's a great point. And we'll come back to the part about how it will be regulated and enforced in a few minutes, if that's okay, Robert. I'd just be good to kind of hear your thoughts as well, Camilla, on the first couple of things that we talked about, your reaction to the, whether it's striking the right balance, and particularly around, how it impacts organisations.
The thing for organisations is, what I think the UK is trying to do with some of the changes that it's making is encourage people to innovate here first. So essentially you sort of make the UK a little bit of a Europe-side sandbox, if you like. And you can see with what's happened with America and the growth of the big tech firms, that having a pretty light regulatory framework, people seem, if you give them a good enough product, they seem quite happy to hand their data over to pretty nearly anybody, but it's got to be really good or they won't. And one of the big challenges that organisations always have is getting people to adopt their brand new innovative product, or the new, even if you're an established brand, getting somebody to take on the new thing that you've come up with is one of the most difficult things to do in business. So there's always going to be a big challenge for anybody trying to work out where that sweet spot is between making people feel like it's safe to have a go and experiment with the innovation that's coming along, but also making the innovators feel like it's safe for them to take that punt. So it's interesting, we've seen with Brexit this sort of desire to take sovereignty back, and most of that seems to be try and have a bit of a lighter regulatory regime than the EU imposes on organisations, and you can see it coming through here a little bit. But I don't know what the rest of the panel think. I think a lot of the changes really are more about people having confidence in what they can already do, right? Rather than anything particularly significant. So for me, I don't think it's doing anything all that dramatic, actually. Most of the time, I think it's just about trying to move that needle a little bit to give people a little bit more, sort of appetite to do something a bit different, and maybe feel like this is a good place to come and innovate. So maybe we get some of that cool tech stuff sort of first. So I think that's what I see from it, and it'll be interesting to see if it works.
Wonderful, great, thank you. That's been some great comments from each of you there. Thank you. I just wanted to touch on the topic that many of our listeners and viewers have raised about, which is just about, so where do we stand with UK adequacy? Hopefully, this is something we might be able to deal with quite quickly. Do we think that the changes could result in any threat to our UK adequacy, or are we feeling pretty confident around that?
It's highly unlikely. They'll have spent so long negotiating and talking to the European Commission and all of the other stakeholders. It's difficult to imagine that they'd have put something through knowing that it would really be a hurdle.
Yeah, agreed.
Yeah, I agree as well, Simon. And there's so much economic analysis and evidence of the value of the personal data flows between the EU and the UK, but the bill would shoot itself in the foot, really, if in terms of claiming economic benefits, if it really jeopardised the UK's adequacy status from the EU. Obviously, the EU has actually extended the UK decision, so it can wait for the detail of the bill. But I think that's just the EU wanting to do its job properly, so it's got the final bill rather than a partial bill before it essentially renew. Hopefully, will very strongly likely will renew the UK's adequacy decision, but I don't see the bill really creating a particular risk. I think the outside risk, though, is just not connected to the bill, but is ongoing developments to the UK's approach to national security and surveillance and uses of personal data in that context. So you can't rule out there being a civil society challenge by someone like Max Schrems in the EU about the UK's approach in that particular area, similar to the challenges which came to the EU-US privacy shield, a number of years ago. So on that area, you could see the potential for some challenge to be mounted. But again, I think the UK has a pretty, strong, robust framework in terms of the Investigatory Powers Act, etc., and what it's got in place. So it's not, it's not necessarily again a really strong area of risk. But I think it's just worth noting that challenge might not come as a result of the bill. Challenge could come for other issues as well.
Right. Yeah, thank you. So just touching on that a little more, you've talked a little bit about national data transfers there, Steve. So there is some plans in DUA to make some changes around international data transfers. Is that something you could tell us a little bit more about?
Yeah, so happy to comment on that. So the key changes are actually buried quite deep in the bill, so you have to read down all the way into Schedule 7, I'm afraid, and persevere or get right down into the depths of it. But the key headline is that the UK, I think, is trying to distinguish its approach from the EU's in terms of what the test is applying when you're considering and assessing a third country in terms of the standards of personal data protection in that third country. Obviously, the long-standing test under the EU GDPR and obviously reaffirmed in all of the European Court of Justice court cases is the test of essential equivalence, which obviously was heavily cited in the Schrems 2 judgment, which obviously was the judgment I mentioned earlier, but struck down the EU-US privacy shield. So the UK, I think, is trying to guard against that risk of that sort of challenge coming here in the UK. So the test now, so that in Schedule 7, will be whether the standards in the third country that's being assessed are materially lower. So I think it's a sort of a subtle switch in language, but I think it does actually allow for, I think, a bit of flexibility. And also, I think if a case does come to the UK courts, the UK will therefore sort of carve its own approach in terms of what the test is to be applied. I think that's quite a helpful thing to do post-Brexit, as we've got our own control over our own data protection law. I think learning some of the lessons from Schrems, and I would say probably the disproportionate disruption that the Schrems 2 judgment caused in terms of the impacts on businesses that in terms of the new processes and procedures they had to have in place for impact assessments, etc. I think it's a sensible step to put in place. The Schedule 7 changes as well also highlight that what organisations should do, what controllers should do when they're obviously in considering additional safeguards. So if the country is not regarded as an adequate third country, but they're using standard contractual clauses and they're assessing the risks and the likelihood in terms of impacts of national security or law enforcement access to personal data in that country, they only need to do what's reasonable, proportionate in that context, and they need to take account of the circumstances and the type of transfer and the nature and the volume of data, which all makes sense in terms of really what we would probably expect in terms of citizens of companies or public sector bodies giving the greatest level of attention to the most important types of personal data transfers. And I think that flexibility hasn't really been apparent in the approach of the European Data Protection Board, which has been a lot more rigid in its approach to impact assessments. So I think overall it's a positive change. And I think the one practical impact could be if there's a challenge to the current EU-US data privacy framework and the safeguards there. Obviously, the European Court will apply the essential equivalence test. Whereas once this bill has passed and become law, the UK will do a different test if there's new issues to consider in terms of what the Trump administration have done to perhaps remove some of the executive orders which underpin that framework. So you could essentially have the position where the EU framework falls under a court case, but the UK one stays, which then actually causes greater complications about onward personal data transfers from the EU to the UK to the US. There's a sort of a wrinkle in all of this, but it's all quite hypothetical at the moment, obviously. But to sum up on and sort of answering the question, I think it's a sensible and pragmatic change that the UK government's proposed on international data transfers. I think it's obviously only going to be more relevant to organisations who are obviously, developing their governance and really focused obviously on transfers of personal data from the UK to other third countries. Obviously, if you're still a multinational organisation, you're still having to be complying with the EU GDPR as well.
But any additional flexibility, I'm sure, will be welcome in the organisations, won't it? Yeah, great, thank you. So Camilla actually mentioned about some areas where it should give us more confidence or give businesses more confidence in the way that they're using data. And one of those might be around legitimate interests. So I just want to touch on that as well. And particularly, there's the clarification around recognised legitimate interests that's come out. But the area that I'd like to focus on really, where we've had one or two questions that have come from our audience, has been around legitimate interests as the lawful basis for direct marketing activity, and putting that onto a more statutory footing rather than it obviously as it has been in the past. So maybe Robert, if you'd like to say a little bit more, because obviously in your role as at the DMA.
Yes, so the DMA pushed very hard to get confirmation that legitimate interests applies to direct marketing. To be fair, it always broadly has. What's interesting when you look at the small print is the fact that direct marketing is now defined in a way that includes any form of communication for marketing and or advertising. So that's where it expands or extends the opportunities for businesses to rely on legitimate interests. Coupled to that, of course, is the fact, as one of the questions has come in, that there will be a list of other recognised legitimate interests where you won't need to do a legitimate interest assessment. And I think that's, on the one hand, very good for business to speed up the process. I still happen to think from a risk point of view, it's still worth having considered the balance of power between the individual and the business, just to ensure the business is not overriding the fundamental rights of individuals.
Yeah, I think that's it's important to have the checks and balances in place from that point of view. But so I think the list of the recognised legitimate interests is quite a select list, a well-defined sort of list, isn't it? As that's the way it's kind of come out. Camilla, was there anything you wanted to add around direct marketing there?
I think the thing With legitimate interests and bringing in that option, sort of option for organisations. It's not quite bringing it in. It's reminding them it's there. Is probably more like it. I think the thing is that actually a lot of organisations that aren't using that basis for marketing at the moment, it's for operational reasons rather than legal reasons, and that doesn't change at all. So sort of I spent quite a lot of last year working with quite a large organisation that wanted to be able to use legitimate interests to work with corporate subscribers. So essentially that's business to business marketing, and you've always been able to use legitimate interests as a basis for talking to them. So nothing's changed there, but operationally it's really difficult, because when they start actually working with the lists, you find that you've got people where you'd need to have a process for moving them between consent and legitimate interest, and sometimes they're one thing and sometimes they're another, depending on whether essentially the same record is interacting with the organisation as an individual person or as a representative of their organisation, and it just gets difficult. So I think it's one thing for the regulators to remind people, but actually finding a route through the challenges that organisations are facing is more complicated than just knowing that there's a lawful basis available. And if the government's really serious about actually making sure that people do make use of those, it probably needs to do a little bit more, rather than just go, let's take it out from the recitals and make it an article, to encourage people to understand what they need to do in order to make use of those things and make it a little bit simpler. And maybe it's something where tech organisations need to be stepping up as well. You know, if it's a database problem, then it's probably a database solution. But yeah, it's nice to see them trying, no?
No, it's good, and I think we should just remind the audience that obviously PECR is still in force. So, from the point of view as as when you do require consent for electronic marketing, you'll still require consent in those situations. But one of the good key areas that I wanted to pick up on is for not-for-profit businesses, for charities that have not in the past been able to benefit from the soft opt-in exemption. So from that point of view, there's obviously that many of those charities will be wanting to look at, should we switch now? We've always had to rely on consent. Should we move to a soft opt-in position, and various benefits that might give, and also some of the challenges that you've touched on there. Robert, was there anything you wanted to add from that point?
Yeah, I was going to say that a couple of charities that I'm advising at the moment are reluctant to move to the soft opt-in, because administratively, picking up on what Camilla's just saying, they've now got to build into the process how they deal with people who opt out, and how do they manage those lists. And often charities simply don't have the resources in terms of people and or systems to be able to do that effectively. And as a chief operating officer said to me a few weeks ago, we're doing all right with the consent method. I just really don't have time to try and do something fancy.
Yeah, that's a good point. And also, is there very much a consumer expectation now that I'll have to check a box to opt in now? And therefore, if we move away more from that you check a box to opt out, which I guess is also familiar when you've already opted in the first place, used to unsubscribe, aren't we? But could there be some element of confusion here for organisations that switch from one kind of from a consent regime onto using the soft opt-in? And
remember the way this applies to charities, it is to charities, not to not-for-profits.
Yeah, that's a good point. Sorry, for charities, I should be clear on that. Absolutely right. Yeah. So touching on another area then that consent is very important, and the options around that too, is cookies. And there's been some changes announced around cookies as well that are planned within the bill, and particularly the practical implications there around kind of analytical cookies, for example, or performance cookies. So is that an area that anyone would like to talk about?
I can pick that one if you like, or start you off. I'm sure other people will want to chime in as well. So this is another one where what the law says that you can do and what difference it actually makes to people is going to be largely operational. I think that might be a bit of my theme for this panel. So essentially what it says is that if you don't want to use cookies that still require consent, you can get away without having to present the sort of cookie banner that people are used to seeing now. But I think you're going to still have a challenge because it does very little of any practical value for organisations that do want to use those cookies. If you want to be using targeted advertising cookies, you still need consent. You might as well collect it. You know, people are largely using the reject all or the accept all button on the banner. They're not really going in very frequently and making specific selections out of what's available. That just doesn't really seem to happen very often. So for them, I can't see them changing the cookie banner at the moment. But for the organisations that don't want to do that, and there are plenty of them, it takes away the requirement to sort of put people through that process. But what you're then doing is you're implementing a change process on your client base, and you're showing them something that at the moment would be a trigger to say this organisation's not very compliant, which for some of your customers is going to be a bit of off-putting. So if you're used to seeing a cookie banner that says, you know, we aren't using any, you know, just sort of we're going to use some cookies to enhance your experience, full stop. That usually means you've got an organisation that's not really very compliant with data protection, and that's not trust and confidence inspiring if you're interested in that. I know I worked at an organisation previously where we chose not to drop any privacy intrusive cookies whatsoever, and really struggled to work out how to word the cookie banner so that people understood that we'd made that decision, not just plonking a cookie wall on that wasn't compliant. And I think you're still going to have that sort of issue at the moment, because somewhat to Robert's point from before, there's an expectation that people have to consent to some things, and it's quite sort of strongly ingrained now. So to get people to understand that actually that's not always the case is going to be quite a process for people to go through, and probably not one that individual organisations will find very easy to do on their own. So I think there's probably going to be quite a lengthy period while people wait for somebody bigger to jump, right? Which they probably won't, because they're probably going to be using targeted advertising cookies. But to get that sort of understanding that this is an option. So it'd be interesting to see whether it really does actually make much difference. It'd be kind of nice if it did, because cookie banners are quite irritating. But I can't massively see it, to be honest.
That's an interesting point, because part of the challenge really is that we're all faced with, you know, when we visit websites, is seeing cookie banners all the time, of varying shapes, sizes, and compliance as well, for that matter. And will that actually realistically change as a result of the bill? I don't know if either of you feel more positively about those changes, Robert or Steve, whether they're likely to see any particular impact. But certainly from my work on the cookie side, the vast majority of clients I've looked at are using targeted cookies, targeted marketing cookies. Not all, but the vast majority. So they may be reluctant to change.
I think, just to add quickly, Simon, I think as well, because you've got so many businesses as well whose reach will go beyond the UK, but they're needing to comply with, you know, a number of different global laws in relation to this area as well. Do you want to start having to serve your cookie banners on the basis of geography and IP addresses, or what benefit would you really get from making all those operational changes, as Camilla was talking about? I think it's worth recognizing that we do have a problem about cookie consent per se, because of it's just so ubiquitous and so prevalent that we just don't, we can't sort of cognitively sort of make all of those real choices every time we're using a service. But my view is it's really an international standards problem, and I don't think the UK could really fix this by itself in a bill. It's going to really require sort of a consortium of some major countries around the world really getting their heads together and saying, can we come up with a common international system to deal with this? Which potentially could go back to some of the discussions we had a few years ago about, you know, using browser signals for sort of general consent signals and the do not track system, etc., which didn't really take off. But I think longer term, that's what the UK government's going to have to do. And I know the EU is really interested in trying to potentially look at this again, because I think they're aware it's sort of seen as a negative thing from GDPR. One of the things that GDPR is seen as having driven is this huge number of cookie banners, which also consumers find quite irritating. So, you know, how do we deal with all of that whilst making sure what we come up with is, you know, privacy preserving and really makes a difference to people having the choice and control, and we reduce the, you know, the risks of intrusive privacy tracking, but also have something which is far more effective for businesses to implement.
Yeah, Absolutely. No, it's definitely a tricky one. So let's pick up on some of the other areas where there's some genuine change with Endure. When I say genuine, I mean as in some very specific requirements that are coming out here, is around the complaints process. So there's a requirement now to have that, to be able to collect complaints and to be able to log those and to respond to those within a 30-day time frame, I believe it is. So I'd like to ask for your thoughts on that, Steve. Is that something that you have? I know that already happens in financial services organisations, but in many other areas, this may well be something new for many organisations.
Yeah, I mean, it's one of the different areas of the bill, because obviously we've discussed actually a number of areas of the bill really about opportunities and choices that businesses, charities and public sector organisations have as to whether they want to go down this route and sort of exploit a potential opportunity. But this is obviously an area where there's going to be a new requirement. So it's something that data protection officers, privacy leads do need to think about in terms of how they may need to sort of tweak, update their governance depending on what they've got in place already. So obviously there will be guidance from the ICO, and I expect the ICO will also consult on that guidance. So I suspect there will be sort of a transitional period in terms of allowing organizations to get ready for this. But obviously organizations of any size already have complaints processes in place, probably to deal with customer complaints and service complaints. So you could probably build on top of an existing process in terms of what you need to do. It's worth looking closely at the wording of the bill, which says you must provide a form which must be completed electronically and by other means. So all of the issues about making sure that your complaint process is accessible to the full range of data subjects. Obviously, don't just think that necessarily an electronic form on your website will be the full measure that will necessarily meet the needs there. But then I think you need to think about some of the things which you will already be doing in your organization, in terms of you already have training in place so staff can spot data subject rights requests. Well, you might need to update that to make sure that people can also spot when a complaint has come in. And then obviously you need to have your roles and responsibilities allocated. Are these complaints going to be dealt with centrally or locally? What's going to be your triage and your scoping process? And then as you've already highlighted, Simon, you're going to need to make sure you can meet within the time scale. You may need to have a process for understanding how to scope and clarify the complaints. And then you also need to have probably, a degree of separation from people who've been involved in it previously, so that you've got someone, who can at least take a degree of independence as well in terms of handling the complaint and what the decision-making process is as well. So, lots of things to think about if you don't really have an effective complaints process in place. But I would say, don't panic, because you've probably already got something you can build on in your organization, and it's probably about revisiting and enhancing your governance rather than needing to start from scratch. And this is good customer service, and I think making data protection sort of work at the first point of contact with the data controller, or after several points of contact, rather than something being escalated to the regulator, I think is the principle behind this. We'll obviously have to see how it works in practice.
Yeah, so the devil's a bit in the detail and find exactly how it all works. But I think you're absolutely right that the aim is for less of those to go to the ICO and for organisations to have a structured process to be able to handle them and deal with them and resolve them effectively for the individual. Yeah, quite agree. Shall we touch on, just conscious of time now, we've got a few more things just to cover before we round up the hour. Talk a little bit about smart data schemes as well, which is one of the, again, opportunities really coming out through the Dual Bill. So that's generated quite a lot of interest around that area. So I know, Camilla, you work in this area. Maybe it's something that you could tell us a bit more about the significance of the plans around smart data schemes.
Yeah, so they're really interesting. So this is the government saying that it recognises the data that is available generally as a strategic asset for the country, for achieving strategic aims, but also for building growth and innovation. And I think there's been a perception, probably somewhat bounded in reality as well, that GDPR has discouraged some data sharing that was actually really useful. Whether that is through actually GDPR says you can't do it, or people are under the impression that it does. So going back to the point that I was making earlier about a lot of this is giving people confidence in things they can already do. But the goal generally is to try and unlock the value in that for things that are socially and personally beneficial. So the one that I work with particularly, I mentioned that I'm sort of connected with the Smart Energy Code, and I chair the privacy subcommittee, which looks after the requirements for making sure that consumers are giving consent to the sharing of their smart meter data. And there is a big program going on at the moment around smart energy data. And the goal for that is it should unlock a whole range of benefits for individuals. So it should be possible to help us achieve climate change and net zero goals by understanding how consumers use energy better than we used to do. But also it should help people reduce their energy bills. It should help with all sorts of different things like load balancing and detecting network faults and handling fraud and a whole range of different things, if only we can share data. Now, what's the biggest blocker at the moment? It's probably not the legislation, weirdly. Legislation's part of it, but actually the biggest challenge that you have when you want organisations to start sharing their data is the quality of the data that they've got available to share. Because it's one of those things where a lot of the time, you know, it's one thing for you to have data and know it's a bit shonky, but when somebody's asking you to share it with the wider public so they can all see that it's a bit shonky, that's actually a difficulty. And so we've had quite a long lead time with organisations trying to improve the quality of the data that they've got and their ability to share it. But that is still a bit of a barrier that, you know, again, it's one thing to know that there are limitations to your data, and so you as one organisation understand that. But when you start taking the data from multiple sources that might be limited, then you have this sort of compounding problem. And all of that needs solving in order to make the smart data schemes work. But the economic, the social, the personal benefit of making them work, I mean, I've only given you one example, but there are so many more. The potential benefits of doing that are so massive that I actually think it's going to be a driver to solving all of those problems. And what will come along with that is that you will end up with organisations that themselves have got better quality data that they can do more with outside of the smart data scheme. So I think that's quite exciting. The other part of it, though, is because all of this is new and it's stuff that people are not currently expecting. And we know, again, with smart energy, that people can have concerns about being switched to a smart meter because they're concerned about who might be able to access their data and what they might do with it. And are they going to use it to do things that they'd rather not have done? And it just generally feels privacy intrusive, and that's a problem all on its own. So with the introduction of smart data schemes that take that data and use it in all of these additional ways, it's really important, I think, to make sure that not just this law, but the regulations that support the law and the activity that goes along with it actually gives people the confidence to sort of enable the whole of the ecosystem and to make use of it. So again, same point I've been making through all the way through, really. This legislation is a necessary piece of the puzzle, but so much of actually solving the problem is going to be operational. And there's going to be so much more sort of wide challenges that will go along with it. But it'd be quite interesting to see what happens. And I think I would strongly recommend that anybody who's interested in this stuff goes and sees what's available out there at the moment, because there's probably more that you can do with your data than you realise right now. And that's only going to get more so as time goes on.
Yeah, that's really interesting. And I guess at sector level, it's getting some level of agreement about what good quality data looks like. You know, so that there is the ability for organisations to share the right type, the right quality, with the right frequency of update, all of that kind of thing, so that they can share it and get some meaningful value out of that they can provide back to society and to their customers. Yeah.
Absolutely. And quality is not just one organisation, obviously. It's also making sure that everybody's having their data roughly the same so that you can use it. So you don't end up with an organisation that all structures their data like this over here and somebody else structures it like that. And it becomes very difficult to match the two data sets together. So there is quite a lot of work to do to make this stuff happen and make it effective. But as I said, if we can make it work, it could be really beneficial for people. but it's really important we do it properly.
Absolutely, totally agree. Shall we move on to the other big topic that we have, which is around digital verification services? So there are obviously plans to produce a new trust framework, as it's called, to set out the rules governing digital verification services, and also to have a new statutory register around the DVS providers. So, Robert, I wanted to hear your thoughts on that. That's okay.
Yeah, sure. So I was in a meeting this morning wearing my notary public hat. As a notary, that's what I do, is verify people's identity. We are being consulted by the department on our experience in this area. It's very early days, but the whole idea of the digital verification scheme is to enable individuals to be digitally identified, not to have to rely on paper. But it will require the government to open up some of their existing information, like passport identity, so that these companies who will be part of the trust scheme will be able to truly identify that somebody is who they say they are. The Land Registry have got a framework already in place. So does Companies House for directors' identities, and it's simply trying to provide a legislative framework to allow for digital identity. But there's a long way to go on it, and there is obviously a need to ensure that the companies that provide digital services are actually reliable. And are underwritten appropriately, and from an individual's point of view, in a world where we have deep fakes and everything else, it's actually quite scary to take responsibility to say that you are who you are.
Quite right, and that's both.
So there's a long way to go on this, but at least the framework is there.
I think that's a really great point, Robert, and that's also both from a data protection point of view and an information security as well. So security is obviously going to be a major challenge when we're dealing with such sensitive information that will verify somebody's identity, as well as all the privacy concerns like who you're sharing it with, things like that, all of those controls. Absolutely. So we're coming up towards time. So just before we round up, I'd just like to gain some thoughts. I think I'll pass this one to Steve, if that's okay, just about what the implementation is going to look like, and whether you see this being kind of more of a phased implementation rather than a big bang.
Yeah, sadly, I think there's a quick and simple answer we can sort of reel off here and just give a nice, easy list of dates because of the diversity of all of the different components of the bill. So, smart data schemes implementation timetable will be quite different to the digital identity trust framework, etc. So you really have to read through the bill and look at what will happen as the next steps in relation to each area. So, for example, in relation to smart data, there's further regulations would need to be laid by the Secretary of State, etc. So there's no one overall answer. And also, the bill allows for there to be sort of what are called transitional provisions. So that means that DCIT, the government department, can decide whether any of the areas, for example, that requirement about complaints, for example, whether there needs to be sort of a transitional period for that, etc. as well. So we'll have to wait for all of the sort of the formal announcements from DCIT as to how the rollout happens. I expect though some of the more straightforward data protection elements could come into effect quite quickly. And also thinking about the points we've made earlier, but a lot of these aspects are about choices rather than a lot of new technical requirements to comply with the law coming in, which are going to force companies to change their governance. That's not really what the bill's about. So some of the data protection elements may come into force within months, I would speculate, but we'll obviously have to wait for the detail from the government. And the last thing to note as well is obviously the ICO will obviously need to update its guidance in a number of different areas, legitimate interests, direct marketing, cookies, etc. So obviously watch for the guidance, and The other important area as well, the government's recognises that the ICO will now develop a new code on AI and automated decision making. So they've recognised that during the parliamentary process of the bill's passage, I think because of some of the concerns that have been flagged. So I think particularly in that area, if you're undertaking automated decision making, you really want to watch what happens with the ICO's planned code, perhaps take part in the consultation and see what's coming up there as well.
That's a good point, Steve. Particularly important, the area that we didn't come back to actually, but you talked about at the beginning was around the changes around automated decision making, specifically for decisions that use special category data, but therefore not decisions that use other less sensitive data from that point of view. So that's a significant change in that area. Okay, with just a few minutes to go, I'd like to just go around the panel just to give your final comments, if that's okay, just to close up. It's been a really interesting session. I hope our audience have enjoyed it. Certainly, I found it really useful talking with you all and hearing your feedback on all of the different areas. So I hope everyone's found it useful. Just before we go into that, it's just I saw it come up on the chat. A couple of people asking is, will there be a recording made available? In case you've not seen it on the chat, yes, we have been recording the session. You'll get an email about 4 p.m. tomorrow if you're in the UK, whatever your time zone, about the start time of this session. You should get it. So you'll be able to watch again if there's any other points that you want to pick up on. So if we just go around and ask for your final closing thoughts, I'll come to Robert first.
Thank you. We know that the work its way through, get royal assent, etc. I think right now I'd be wanting to make sure I know my data estate, understand the provenance of the data that we've got. I think the smart data scheme is going to lead to more data portability requests than perhaps we've ever seen. It's always been there in GDPR, so I'd certainly want to be sure that we know what we've got and we know how to respond to individuals who exercise their rights. And yeah, I think this is very living and breathing at the moment. So it's, as Steve said, keep an eye on what's coming.
Right. So it's know your foundations from a data protection point of view. Absolutely, Robert. Great. Camilla?
I think one of the things that I think people can take away is, as I've said through this session, a lot of it is just reminding you can do things you can already do. So you could start preparing now. You don't need to wait for royal assent. This isn't something that's stopping you doing things. It's giving you an opportunity to do them, and often things you can start doing now if you want to. So my takeaway for everybody here would be to go and have another look. What would these sort of extra freedoms and opportunities, what might they look like for you? How could you take up sort of advantage of them, and what might they be able to do? Because you could start planning for that as soon as you like. So why not?
Wonderful. Thank you very much. And you've just been complimented on your fish, by the way.
I will tell them. They'll be very pleased.
And I should close last but not least until Steve. I'd like to hear your kind of closing comments, if you could, please.
Yeah, I think just echo some of the points that should be made already. But I think a lot of the bill is really about opportunity assessment. So, thinking about where it's really beneficial to take advantage of what the bill is offering, about how you need to make a decision about what the value is in sort of perhaps having to change your governance, your policies, your processes, working out why this is relevant for your sector and your types of business, because it will vary from area to areas it also, I think, the size and scale of your business, which markets you operate in, as to whether this is going to be useful for you. So, you need to do your own sort of individual look at where you want to sort of exploit the opportunity. And I think I would very much agree with what Robert and Camilla have already said. Also, just to pick up on one thing that Robert said, I would echo as well. On data portability, which is obviously a sort of a right that already exists in GDPR under Article 20, it's obviously sort of a precursor to smart data to some extent that hasn't been heavily used. But I'm also actually noting a pickup in some organizations I've been working with are getting more data portability requests at the moment, and some third parties are facilitating that process and sort of enabling it, for example, in the retail sector. So it is worth thinking about, being ready in the data portability area, because you may get some sort of pathfinder requests if it's relevant for your sector and type of business, to think about that as well.
Brilliant. Thank you very much, Steve. So it's been some terrific comments that you've all given today. Thank you ever so much. So thank you to all the panel who've given your time so freely for everyone. And I hope our audience have all found that useful. Thank you all for coming along today. And to anybody that's watching the recording at a later date, hope you find that useful. So we'll close there. We're just about up to the hour. So we shall say goodbye. Thank you all very much. Take care.